take notes, you want to go ahead and take a stand? We were in where we left off.
So you want to go ahead and, I know Mr. Brady needs to work with the video, but we can, do you want that shut down or should we want that? Or at least switch to his laptop from mine?
No, I guess we can leave it on. I don't necessarily anticipate using it. But if something were to come up, there are.
Okay. All right, feel free, man. Please.
Thank you, Your Honor. Detective, congratulations on your promotion.
Thank you.
Since the state, when did that happen?
This past January.
Well, congratulations. I apologize for my sweat right now. I was running up the stairs not to be late for court.
Yes, sir.
So, I'll try to cool down as we go on. You would agree that the purpose of the incident report, y'all's incident report, is to record, and just to be clear, you did file a supplemental part to this incident report, correct?
I did.
And obviously, all the observations that you make, all the important cues and observations that you make are on that incident report.
Yes.
Correct? And you acknowledge that you didn't ever mention the smell of alcohol either, correct?
I did not mention that.
And you would agree with me from your years of experience that that is one of the, if not the most common, of alcohol intoxication, is the presence of the smell of alcohol.
I would say it's one factor in that, yes.
Okay. And it often serves as probable cause for you to go on with other tests and other factors.
It could lead to probable cause, yes.
Okay. And also slurring of speech. You at no point ever mentioned that you heard him slurring his speech, correct?
That's correct.
And that likewise is a common symptom of DUI, a cue for DUI.
It could be, yes.
Okay. And then you likewise agree then that the driving that we saw in the videotape, other than not having the lights on, everything else was appropriate.
From what I saw, yes.
Okay. And I don't need to go back, I guess, over everything, but, you know, he used his turning blinker twice.
Mm-hmm.
He stayed within his lane. He made appropriate turns, and he stopped when you stopped him.
That's correct. Mm-hmm.
And then had he not, then those would be other charges you could have charged him with.
Possibly, yes.
Okay. And we heard on the videotape that you likewise, you mentioned that your wife has ADHD when you were discussing this with the female that was there with him. Is that correct?
I did mention that.
Okay.
That is, if I could say, that was, I actually misspoke. That's not correct. I've since spoken with my wife since the traffic stop.
Okay.
She does not have ADHD. I thought she did at the time, but we've had conversations since then, and she is not diagnosed with that.
Okay, that's fine. Was it ADD then? Was that?
I'd rather not say unless.
Oh, no,
yeah,
that's fine. I don't need to know.
It's not ADHD as I thought it was at that time.
Okay. And would you agree that my client's conduct throughout the night, at least verbally and in some other areas, was hyperactive?
Depends on how you define.
Objection again, Your Honor. Just to be clear, he's asking this detective to give a medical opinion about the symptoms of ADHD. I would object to that.
I'm not talking about ADHD at all, Your Honor.
Well, as long as you understand that he's not giving a medical opinion.
Yes.
You're not
Yes,
asking
ma'am.
for one.
Yes, ma'am. Just hyperactive, the general sense of that term, not the medical.
If the definition of hyperactivity is constant talking and raising of the voice oftentimes, then yes.
All right. And do you remember making the statement at around 2:37 on the tape when he told you it was it's a big deal that he has ADHD? Forget, I'm not asking you what it is, but he said it was a big deal, and you said it is a big issue. You remember saying that?
I don't recall meaning that ADHD was a big issue. There were several other things that he mentioned that he felt was important that I may have attached that statement to.
Would you like to see that section at 2:37 of the video to refresh your memory? Would it help you refresh your memory?
Sure, it would.
Let me ask you this. Do you remember him telling you that ADHD is a big issue in this case? His ADHD is a big issue.
I don't recall him telling me that directly, no.
Okay, then I suppose we would need to. If you don't, I'm not sure how we do that. You what? what now? Okay, I'll pay you.
The video, the court reporter has a video.
Oh, thank you. I'll roll this around. So
Just got you tell them when you want me to hit send all. And I will.
Your Honor, will this be okay that I stay down here since it's going to be short? Or
If it's
would you-
okay with the jury, it's okay with me.
Okay. The time would be 2:37 on the timer.
You can, but my concern is about,
The only thing I know about checking, please, I'm fishing poison is supposed to look.
it sounds like bad stuff.
They wanted me to work.
Another minute.
Doctor, I actually am MD. But you know what? They took away the medical license,
Sure, yes.
sold to the damn ships. But they were going to abandon in place and leave in Panama at the Jungle Training Center.
Right.
And I said, fuck that. I'm taking the contract. And we will take them. No, you guys don't know because you haven't served. Which have you served?
I
Which have you served?
haven't served, my father served, and I haven't. I'll put your cash in the front pocket, okay?
I appreciate that. That's nice. It's better than what they did in Meridian, Mississippi when I had cerebral malaria. They weren't able to recognize the difference. I had cerebral malaria with a 0.00000 alcohol content.
Right.
I couldn't tell the difference between cerebral malaria and alcoholism. That's a big issue.
That is a big issue. I
It's a
understand
major
that.
issue. I used to be 11 years I served.
And I apologize, I think I asked you ADHD being a big issue, but honestly, the cerebral malaria was the big issue that you agreed with at the time.
Okay, that was making small talk. I was trying to get him calmed down to be agreeable. He was in an excited state.
Sure.
And I felt that just more or less agreeing with whatever he was telling us was the best course of action at that time. To
Okay,
make sure
so-
everything stayed calm.
You in fact don't think it's a big issue?
I didn't say that. I don't know what cerebral malaria is. I'm not familiar with that.
Okay. Did you see him, was he showing you, did you see him showing his head, the blow
I
on his head that he?
I don't recall that, no.
Okay. So, had you thought, in fact thought it was a big issue, I mean, had
I'm
you,
not gonna object to Mr. Foster's apparent effort to show the jury his head right now. He's not on the stand, he hasn't been sworn, and I don't think that's appropriate.
Mr. Murray, would you caution your client that he is not to be demonstrating anything, he needs to sit quietly and pay attention to the trial?
yes ma'am, I just did. Had you meant that statement, would it have made any difference in how you processed any of the results that you saw, or any of the results that you observed?
I don't believe it would have, no.
Okay. Would you have called, do you think you might have checked with the crime lab? Do you think you might have checked with any medical personnel regarding that particular issue?
I don't believe so, no.
Okay. You agree likewise with the other officer that these field sobriety tests do focus on multitasking, divided attention, and that sort of thing?
That's correct.
All right. Someone with an attention issue might have difficulty with these tests, drunk or sober.
I have no idea.
Fair to say?
I don't know.
These tests take undivided, or will take divided attention
Yes, sir.
to successfully complete, correct?
It's one of the things that it tests, yes.
Okay. There are other, now, it seems like you had, I heard you in the transcript said you had like 100 DUI stops, you estimated?
Something like that.
Okay. Did you in any of those stops ever perform other field sobriety tests like the Romberg, touching the nose, thumb to each finger? Alphabet?
There may have been one or two like that, but that's commonly not part of my procedure if I have a DUI situation.
Would you do those types of tests, though, if you had any concern about the person's physical ability or equilibrium not related to intoxication? Would you have potentially done other tests, had that occurred to you?
All I can speak of is that night, and no, I didn't have any intention of doing those tests.
Is that why you did the test on the other occasions, though? Because
I can't recall exactly. Those were a long time ago. I can't recall why in those 1 or 2 occasions that I chose to do those tests.
Okay, but that would take a decision on your part to deviate from the 3 standard tests that are used?
Yes, sir.
Okay. And one reason for that deviation could be the physical capabilities of the defendant?
I couldn't guess to say. I'm not sure.
Okay. Do you remember, you were under oath at the hearing the other week. I want to ask you a couple of questions about the test in the wake of the implied consent being read. Do you acknowledge that in your mind, using your words, in your mind, he was asking for the blood test to be done by Hamilton and that you would accommodate that request?
Yes.
Now, that was not the additional test, that was the initial test, as you described it that day.
The state test.
Right.
Yes.
I don't want to ask you anything about the additional test because it is what it is, but I do want to ask you about the initial test. In your mind, you were accommodating him by doing what he was asking you to do about taking him to Hamilton to do the test.
That's correct.
Okay. And do you remember stating that in your mind there's no difference between a blood draw and a blood test?
That's correct, according to the language on implied consent.
Okay.
It just says test.
But you heard the testimony earlier, since you've been in here, you heard the testimony of the crime lab person stating that it's important not to confuse those terms.
There was some discussion of that with her testimony, yes.
Okay. So but I just wanted to make sure you do remember and you acknowledge saying that in your mind, there's no difference between drawing the blood and testing the blood.
Well, it's not just in my mind, that's what's written on the implied consent notice for all law enforcement in Georgia.
Where does it say there's no, I believe the implied consent is in law, is in evidence. Would you show me where it says there's no difference between those two terms?
Well, that's not what I said. The verbiage on the implied consent says test. There's no verbiage that says a difference between draw and test.
The issue's not raised in on the card.
No,
Okay.
that's correct.
And nowhere until he'd already given his blood was the word draw, blood draw, ever even used on the video, anywhere from start to finish, up until the time the blood was actually taken.
It's fair to say that the word draw was not used.
And in fact, he asked you on the way to the hospital, and if you don't remember this, that's fine, but he asked you, what happens if I do well, if I end up being low on this test? You remember him asking you something to that effect?
I remember him challenging us to some sort of race when the test comes back, or I don't think he said necessarily when the test comes back negative, just when the test comes back. He offered some sort of challenge like that. That's all I recall from that conversation.
All right, and you do realize that had the test been done at the hospital, test, not the draw, but the test had been done at the hospital, you would have had a result that night.
I have no idea.
Okay. You didn't inquire or check into that?
That's not part of our protocol, no, sir.
Well, it's not part of your protocol to agree normally to let him dictate which initial test he takes. Y'all usually ask that.
Okay.
So
Yes.
and you graciously acknowledge that you accommodated his request by taking him to Hamilton, the place where he told you he trusted, to do the test.
If he would rather do the state test, not breath state test, but if he would rather have done the blood state test, then yes, we were willing to have that done.
And my point is, in the sense, you heard the crime lab witness up here, in the sense she used the word test, you did not accommodate him because Hamilton did not do the test, in fact. Correct?
They did the blood draw,
They
which
did?
in our, according to our training and our procedure, is you draw the blood prior to it being tested.
You heard her distinction between the two. What I asked you was the way she defined test, you did not accommodate him the way she defined the test.
Well, that's true, but we're not required to have the test done right there at the hospital at that time.
You could have told him, no, we're going to do the breath test is what we're requesting. You could have stuck to your guns about that, correct?
Well, our impression was that he was refusing the breath test and that he was not going to do the breath test.
He never said on the video he wasn't going to do the breath test. That's the first thing he asked for, in fact, was it not?
The Alka-Sensor test, which is different, that is the side of the road breath device that we use. That is not the state test.
Well, my point is that you said at the hearing the other week that y'all accommodated his request. All right. You understood, honestly, that when he said Hamilton to do the test, he meant for them to actually do the test in the way
No,
the
sir.
crime lab person. You don't
That's
think
not-
he meant that?
I don't know what he meant, but I know that that's not our protocol according to applied consent.
If your position is you accommodated his request, then it does matter what his request, what you thought he meant by his
Objection, Your Honor.
request.
He's arguing with the witness.
I sustain the objection, that's all I can do.
How many vials did y'all take? Do you remember?
There's 2 vials in the test kit.
Okay. And of course, you don't claim to have any knowledge about decomposition, fermentation, or anything that was or was not in that test tube.
That's correct.
Correct?
Right.
But what you do, what you can help confirm is that the test tubes with the blood were not sent immediately to the crime lab.
Not immediately, no.
They weren't sent the next day, the next day, the next day, the next week, the next week, the next week, right?
When we placed the kit into evidence, as Officer Smith had testified, I don't know at what point it went to the crime lab.
Okay.
It could have been the next day.
Well, you heard the testimony that it was received on October the 18th.
Okay. I don't know when, all I'm saying is I don't know when it was sent to the crime lab.
Okay. So was this, but it was the other officer's duty to send it, not yours?
Well, me being his training officer, it was
Right.
both our duties to make sure that kit was entered into evidence as soon as possible.
Well, he's the one that actually sent it, though. Is that your understanding as
We
well?
didn't send it. Do you mean put it into evidence? Is that what?
Put it in evidence, and who mails it?
That's our property and evidence personnel at the police department physically take any evidence that the crime lab needs to process. They take it to the crime lab themselves.
Hand delivered.
Yes, from what I understand.
So we can assume then that the mail, the 2 or 3 delay in the mail, if it had been mailed through U.S. mail, that this was not in fact done by U.S. mail, but if policy was being followed, somebody from the evidence locker on October the 18th, almost a month later, would have hand taken it to the crime lab.
I'm not sure when that was done, but yes, that's how our procedure is when dealing with GBI evidence or evidence that the GBI is going to test.
Well, that was just my question, with the report saying it was received on October the 18th. We don't have to factor the mail time in that.
You keep bringing up mail time. I don't think we're talking about mail time.
Right, that's all I'm
That way,
saying.
right.
That it would have been,
I don't think it was mailed.
it would have left y'all's care on that same day and been hand delivered to Rome?
It's in DeKalb County near Atlanta, the crime lab.
Okay. But until then, to your knowledge, it's just kept in an evidence locker.
That's correct.
And you were aware at the time that he was a man in his 60s? Or were you aware of that?
I can't recall being aware of that. I hear on the tape that he said he was 61 years old, but I can't say that I heard that night.
Okay. All right, if I can have just a moment, Your Honor. That's all, Your Honor.
Need a redirect?
On behalf of the state judge.
All right, you may step down. That's your next witness.
Your Honor, at this point, the state would rest.
All right. Murray?
Your Honor, could I check for a witness?
Sir.
Mr. Murray, but this is my office laptop, so my emails will be popping up if we don't minimize
If
my
you would go ahead,
screen.
I will kill the video.
It's just gonna ding and ding if we don't.
And
Take the stand up there, please. All right, raise your right hand, please. Do you affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Tell the jury who you are, please.
My name is Debbie Peppers.
And where do you work? What's your occupation?
I'm retired now, but I'm an attorney.
All right. Who did you work for when you did practice?
The last office I worked for was Warren Coppage.
All right. And what other work did you do in the court system over the years?
I served as a volunteer for years down at juvenile court on panels. I do a little volunteer work now with legal aid.
All right. And obviously you know Stephen Foster, is that correct?
That's right, he's my cousin.
All right. And how long have you known him?
Well, he's my first cousin, and I'm older than him, so I've known him his whole life.
All right. And where, in what geographical area have you been in Dalton all this time?
Pretty much. I was moved down to Madison shortly after getting married, but I came back after about 5 years.
Are you familiar with the character and reputation of Steve Foster in the community?
Yes, I am.
And is that character good or bad?
Good.
And truthful or untruthful?
Truthful.
And would you believe him under oath?
Yes.
Now, have you observed the video of the DUI stop in this case?
Yes, I sat through part of it. I didn't hear the whole hour.
Attorney, may we approach?
certainly. Now, Ms. Baxter, you want to restate your objection, please?
Yes, Your Honor, I understand that from the initial questions that Ms. Peppers is a character witness, and the limited purpose of a character witness is the defendant's reputation for truthfulness, reputation in the community. There is nothing that would indicate she's a witness in this case that can testify by any facts. But if she's a character witness, the limited purpose of that testimony is his reputation for truthfulness, and that's all she can testify to. She can't watch a video and then talk about what happens in the video as a character witness.
I'm not asking her to make any comments on the video. I'm asking her as to his normal tone of communication. Apart from that, has she, just to compare the two, not to draw any conclusions about the video itself? Your Honor, 24-4-405B says, as a general proposition, on direct examination, defense counsel may not go into specific instances. But whereas here the defendant testifies, and I will state in my place that he is going to be testifying to his good character. If the court wants to hear that first before deciding, I'll stop the interrogation here and then put him up and then put the witness back up unless the court wants to go ahead and rule on it in the event that that were to occur. The defendant can clearly get into specific instances of his own good conduct. And if he does that, that allows his witnesses to as well.
Your Honor, I don't believe that there's any exception that allows a specific incidence of character brought in by character evidence simply because the defendant chooses to testify. I don't believe that that's in any way what the rule says.
I read it. Your Honor, word for word, 24-4-405B.
I'm looking at it too.
But whereas here the defendant testifies as to his good character, and such character is an essential element of his defense that he is...
I think that's what you got right there, that's the problem. Specific instances of good conduct not admissible to negate criminal intent. The criminal defense generally may not bolster their defense of the specific acts of reported good deeds under Rule 405. I think it's got to be an essential element of the crime. Get into that. Is that what it says?
Well, I take the essential element of the crime being here, his honesty and how much he had to drink that night.
Is honesty an essential element of the driving under influence?
It is not, Your Honor. The law is clear that the intent is to drive, not the intent to have honesty or specific course of conduct. The intent required is to drive.
The honesty that he is being truthful about how much he had to drink that night, which, if he is being honest, could not support the blood alcohol reading in question.
Your Honor, this is getting ridiculous. You cannot bring in people to say, I don't believe he would drink that much, as a defense to a DUI.
No, I'm not asking that. You're presuming that.
That's what you just said. You said it would negate the blood alcohol content if she said that this was that he was an honest person. You can't.
And she's given the general character testimony, and my understanding of the law is that unless character is an essential element of the crime, then you cannot get into specific instance.
DUI, Judge, is a general intent crime. It is not a specific intent crime. You do not have to intend to drive under the influence. You only have to intend to drive.
Your Honor, time and time again, in Georgia Handbook on Evidence, in section 432, he says, I'm reading in here on section 432, on page 239, that specifically allows an accused when testifying as to his or her own character to refer to specific instance of that person's conduct.
Two things. That applies to specific intent crimes. Number two, it allows the defendant to testify to those things, not a third party.
The third party, Your Honor, I know of no restriction on a witness to be able to testify as to someone's general demeanor generally, not on the night in question. But for instance, we have here a person that's loud, we have here a person that's bombastic, and I think I should be allowed from witnesses who have been around him in social situations, nothing to do with alcohol. I'm not even bringing alcohol into it. They should be able to testify that he's that way. Normally, when they see him, he's bombastic, loud, and stream of consciousness.
Your Honor, that's not what character witnesses are for.
I'm not...
Ms. Baxter's correct. And I'll point you also to U.S. versus Keister, if I'm pronouncing that wrong, at the Ninth Circuit. And the relevant inquiry for determining whether the character of a person is an essential element is as follows. Would proof or failure of proof of the character trait by itself actually satisfy an element of the charge, claim, or defense? If not, then character is not essential and evidence should be limited to opinion or reputation. And I think that's the situation we have here. This is not, character is not an essential element of this crime.
Yes, ma'am. I would just say the state's case clearly is hinged on his conduct that he displayed on the videotape, his tone, his bombast, that's being offered as evidence of inebriation. All right? If he's that way normally, I should be allowed to get into that if that's the way that he normally talks and normally communicates. But I understand on the character issue.
And I don't believe I asked any questions regarding his tone or demeanor or anything to elicit that his behavior was somehow indicative of. In fact, Your Honor, I specifically didn't ask any questions about his behavior or what clues other than what he initially told Officer Smith led them to believe he might be DUI. I certainly didn't open the door to that, anything like that. And I don't believe it would matter if I did. You still aren't allowed to prove through opinion of specific instances of character witnesses.
I think she opened the door when she played the video, showing it for an hour, for no other reason than to hear his audio tone and the bombast with which he was sharing. I mean, why on earth would that even be played if it weren't for that, if that wasn't the reason?
Your Honor, it's the video of the of the crime. It's
Your client needs to stop.
All right, just... Your Honor, the other issue, if I could request the court, is the court's ruling. I understand where the court is headed with this ruling, but is the court's ruling that a character witness can't testify to any other factual matters he or she may not know about? I mean,
No witness can testify something they don't know about.
well, obvious. I misspoke. It matters that he knows about.
That's true. You want to go around that?
Your Honor, if a person has factual knowledge of the case, they are by definition not a character witness. If the purpose they're being offered is to establish the defendant's good character, that means that they don't have factual knowledge of the case. So you can't be one and both at the same time.
Your Honor, I propose that I should be able to, again, get into what she knows, not about character, but about his general way of communication. Is he loud? Is he soft? Is he stream of consciousness? Does he go from topic to topic? Is he dominant? Does he, does he keep talking without soliciting questions? That's what was shown on the video. I think I should be able to ask her what she knows about his communication skills.
Except to continue to say it's not relevant, and a character witness is not allowed to say that. I'm not exactly sure what else to say.
Well, it doesn't fall under the category of character witness, and it's not really having anything to do with the issue that we're here on today. The issue we're here on today are the events of that evening and that traffic stop and the subsequent events. So I don't know that that would be relevant in any way.
Well, Your Honor,
Unless she's going to testify, Your Honor, that she was, for example, with Mr. Foster at some point during the evening, she observed him drink one alcoholic drink and that's it, and she has some knowledge of the events of the evening or the traffic stop, I don't know what she has to offer other than what she's already testified to.
Your Honor, I think the question is it reasonable to expect that the jury could potentially hold his conduct, his form of speaking, against him and as a sign of inebriation? If that's possible in this case, I think it's readily inferable whether she mentions it or not. She played the videotape, which doesn't even show him physically for 75% of it, just so his audio, the inflections of his voice and the loudness of his manner and the outrageousness of what he is saying be shown to the jury. It's obvious, whether she argues it or not, the jury has seen it, and is that a logical inference that they would hold his conduct, his tone that night as some evidence of inebriation? I don't think it's outrageous to think that they could do that. But if he talks that way all the time, even when he's sober, that matters. And why I wouldn't be able to get that through a fact witness, who is also a character witness, but in two different ways, obviously, then I don't understand why I shouldn't be allowed to get into that.
I'm just trying to figure out how she's a fact witness to anything that happened that night. I think what you're going for is reputation and character, and specific incidents are just not allowed in this case.
Well,
Character is not an element of this offense.
I don't even think that the tone of voice and someone's way of communicating is a question of character anyhow. I mean, that's just a physical manifestation. That's a personality issue. That's not a character issue.
Well, Judge, he just defeated his own argument.
Well, I can argue in the alternative.
If the argument is that he's going to be convicted based on the tone of his voice, then and that's not character, then we don't need a character witness, then we can't bring a character witness anyway. I mean, it's a circular...
It is a circular...
It's a circular reasoning. She should be allowed to testify because she's a fact witness, but she's not really a fact witness because she doesn't know anything about the night. She's a character witness, and she wants to talk about how he usually is. That's not...
She has peripheral knowledge of the way that he communicates. This jury does not know how he normally communicates. If witnesses who are around him frequently know how he communicates and not be able to describe that he is normally loud, often abrasive, bombastic.
Judge, being loud, bombastic, abrasive are not elements of this crime. It's not relevant to
It's
this.
evidence.
They're not elements of the crime that have anything to do with character. And so you can't...
I'm abandoning the character argument, Your Honor.
Okay.
So just the question is, can a character witness also testify?
But I don't think that what you're asking is relevant.
I understand the court's take on that. I just believe that it is. If the court believes that the way he talked could reasonably be held by any of these jurors against him or in support of his intoxication, then that's relevant. I mean, if there was no way that they could take the way that he talked against him as any sort of chip in this, any sort of evidence chip, I would agree with the court. But I'm being honest. I think that some of them might take that as evidence that he's talking like a drunk.
At which point, Your Honor, he should have objected to the playing of the video. If that was his argument, that this video was more prejudicial than probative, he should have objected to its being played. He sat there. He cross-examined the witness based on the video.
There were positive things.
He doesn't get to complain about it now.
Well, there were positive things in the video. If the court, I understand the court is not inclined to grant this, and I'll move on from it.
Okay, then good. Let's move on.
All right.
Anything else? Or bring the jury back in. Yes, I'm sure the court will appreciate y'all suggesting the jury be taken out so that she doesn't straining to hear. All right, you'll bring it back in, please.
I'll need my witness. Could you? Well, actually, I'm going to be through with her then. She's done with her character testimony. Which means, let me get my other character witness. With the court's permission.
Your Honor, I still believe, even though I would be entitled to cross-examine the witness, I don't believe we're done with her quite yet.
Oh, that's
Oh,
I'm sorry, yeah. That's right, Mr. Murray. We never got to that part. Go ahead and say it, please. Can you cross on this witness?
Not on behalf of the state, Judge, she's excused.
All right, you may sit down. For our next witness. Mr. Murray, as a client, please keep your voice down.
Yes, ma'am. Raise your right hand, please. You affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Tell the court and the jury who you are.
My name's Gary Cruz. I live at 1011 DeSoto Drive, Dalton, Georgia.
Tell the jury what you do for a living.
For the last 15, 16 years, I've been practice manager, or been working at Med now. The last several years, practice manager. I have a real estate license, and I also serve on Dalton City Council.
Okay. Have you served on any other committees or councils or?
Multiple community boards.
Just give us a couple of three if you would.
Whitfield Adult Daycare, Employer Committee, there's numerous ones through the city, liaison to several boards as well.
All right. And do you know Stephen Foster?
I do.
And how do you know him?
I met Steve back in mid-70s when he first came back to town. I managed an athletic store at Walnut Square, and at that time he ran a lot, did triathlons, I did too. We used to bike and run quite a bit together.
Okay. And what is the length of time that you've known him?
Probably 30-some years, 35, 36 years, from 84, 85 until present.
And are you familiar with the character and reputation of him in the community where he lives?
I am.
All right. And is that character good or bad?
I think he has a good character.
All right. And is it a character that's truthful or untruthful?
I think he's overly truthful sometimes.
All right. Would you believe him under oath?
Yes.
All right. I believe that's all.
Questions for this witness?
I have no questions, Judge, she's excused.
All right, you may sit down. Keep your witness.
Raise your right hand. Do you affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I so affirm.
All right. Have a seat, please. Tell the jury who you are.
My name is Steve Foster, Stephen Lamar Foster, actually, Stevenlamar Foster. I am pretty much a lifelong resident, except for the time that I've lived in either another state or something during training or deployments or out of the country.
Let me ask you some specific questions. Where did you grow up, and where did you go to high school and graduate from?
I grew up here in Whitfield County, on the east side of the county. I went to county schools, and I went to graduated at North Whitfield, not Northwest, but North Whitfield.
Oh, did I say Northwest? I apologize. All right, and then you went on to get higher level training at what occupation?
Well, my first occupation was as an EMT. When I went to the University of Georgia, I took night classes at Athens Tech and became an EMT, worked with Clark County EMS, and came back and worked with Murray County Emergency Medical Service in summers or on vacations or in between breaks, even in medical school.
And you went on to complete your medical degree?
I did. I graduated at a veterans school in Tennessee and East Tennessee State, and then I went from there. I went to South Carolina, where I spent the next 4 years in training programs at Richland Memorial Hospital in emergency medicine and Spartanburg General Hospital, which is now Spartanburg Regional Medical Center, but same thing. There, finishing that up in December of 1987.
All right, and what did you could go on to practice medicine in this area?
Yeah, I was hired at Erlanger Medical Center, but When I was the week before I was scheduled to report there, the personnel director for the emergency medical service said that they'd had an opening happen, a sudden opening happen at Hamilton Medical Center, and would I mind going there? Clearly, they'd never read my resume. I was just another fill-in-the-blank person, but they didn't even know I was from Dalton, so I was happy to return home at that time.
And how long were you an emergency room physician?
3.5 years.
Okay.
Well, I've been an emergency medical physician and had been practicing in South Carolina for 2 years before that at Rock Hill, South Carolina.
All right. And when you were an emergency room physician in Hamilton Medical Center, did you yourself ever send medical DUI results to the Georgia Crime Lab?
It was a standard policy at the time.
I'm going to object, if we can approach. My apologies.
I'm going to ask the jury to step back out, please. All right. Now, Ms. Baxter, would you please restate your objection?
Your Honor, I would object to Mr. Foster's being allowed to testify about what, first of all, was standard operating procedure at Hamilton several years ago, much less today. Second of all, I feel like we're about to go down a path where Mr. Foster gets to simultaneously testify as the defendant and some sort of quasi-expert witness about blood tests and about what should and should not happen. The essential element, Judge, of an expert witness is that they are an unbiased witness. And I can't think of anybody more biased than a criminal defendant to offer testimony about what blood does and doesn't do and how it should or should not be shipped. And I think that's where this line of questioning is headed.
Your Honor, it goes, bias would go to weight, but not admissibility. There's not a case out there that says that a defendant who also has expert knowledge about a particular situation can't testify to it.
Your Honor, in qualifying an expert, the very first question that is asked, the very first Daubert question is whether the witness has any investment in the case before them. That's the very initial question in qualifying a witness, is do you have any investment in this proceeding one way or the other? There's nobody who's more invested than the defendant in a criminal case.
Your Honor, he's allowed to explain why he made the request that he did regarding going to the hospital and having the test done that night. He has the right to explain why he asked that and what were the reasons behind it.
There's a difference in explaining why he asked that night and going back and talking about what the procedures were years ago and things that are not relevant to this trial. It is relevant. I'll grant you it is relevant as to why he asked for a blood test that night.
Yes, ma'am.
But it is not relevant as what procedures were years ago, and I do not believe that the defendant can testify as his own expert.
Well, except to the extent that it explains.
What procedures should be and what should and shouldn't have been done. But he can't explain why he chose that, but that's a pretty fine line to walk.
Yes, ma'am. I wasn't going to ask any more questions. That was the only question that I intended to ask about anything from Hamilton Medical Center from way back. I do intend to allow him to explain why he asked for that particular test that night.
Well, and Your Honor, again, if we're going to get into issues of test reliability, if he's going to start talking about the unreliability of HGN or Accuses or a breathalyzer, he cannot be the defendant and testify to those things.
No, I'm not asking about any of those things.
Well, you know, what might be a good idea is to just do a little proffer so that we don't bring the jury in and have objections again, and then have to send the jury back out. What do you think of that, counsel?
Yes, ma'am, I'm fine with that.
Okay, is that, you fine with that?
Yes, ma'am.
I think that might be a neater way to do this.
You want me to get it through questioning or just state to the court what I intended?
Might not be a bad idea to get through questioning.
All right. Let me ask you about the reason that you asked that night. There's been testimony confirming that you asked for the test to be done in Hamilton Medical Center. Why is it that you wanted that to be done there that night?
Hamilton Medical Center does an enzymatic assay test. You can get the results back within maybe 45 minutes. If you put it on like a prompt, or you need a prompt result, they'll even speed it faster. But in no case would the test have taken longer than 2 hours. And the other issue with an enzymatic test, you get an immediate result, and you don't have the potential for alcoholic fermentation to occur in an anaerobic environment inside of a gray test tube that you're not even, that we've already heard she didn't ever even add the sodium fluoride to.
Well, let's try to streamline it.
Sorry.
And just say you were aware of that issue, and that your awareness of that issue did play into your decision to ask for it to be done that night.
Yeah, I knew how much I'd had to drink, and I knew what I would blow. I knew what it should show.
Right,
But,
and I don't, so if
sorry.
we get into this, I think the court wants to know that I'm not going to be asking you for elaborate opinions about this, that, and the other with different types of medical tests. What you've just stated is the reason why you asked for that particular test that night.
And I thought I'd be going home. In fact, was told that I'd be bonded out. I wasn't even bonded in.
That's
I
fine.
wasn't even, put into the jail till the following day. They kept me there to beat me up.
This is the subject of the motion in limine the court's already ruled on.
The court's already ruled.
I don't know the beat.
Mr. Foster.
And I've instructed, and we've talked.
Yeah, there's no jury here, Your Honor. to hear it.
Well, I've instructed you, we've got to be very careful of what we
Sure.
say, we are in agreement, Your Honor, that what you ruled on is not to be talked about. So that's not to be revisited. You ruled.
Ms. Baxter?
Your Honor, if the substance of the testimony is simply why he chose to ask for a blood test at Hamilton, I think that is admissible. I don't think that he, as a defendant, can also testify about relative reliability or scientific methods or anything of that nature.
Your Honor, I think you should be able to say at least that he preferred that test for its immediacy and he felt it was more accurate without getting into why.
I think as long as he doesn't go into why and it's the accuracy of the test and it's things that would be expert opinion, then what you're saying is fine. You might want to take a moment with your client and help him understand my ruling, though. Why don't you do that?
Yes, ma'am. Would Your Honor want me to do that out in the hallway?
I prefer you do that back, actually.
Judge, while they're having that conference, may I step out to the restroom, please?
There you go, counsel.
Yes, ma'am.
You'll bring it back in. Whenever you're ready.
Thank you, Your Honor. Now, I believe we were at Hamilton Medical Center, you being an emergency room physician there for 3 years. Where did you go from there employment-wise?
I opened a small workers' comp urgent care clinic on Walnut Avenue,
What was the name of that?
Mid-Now.
Is that still there?
No, not at that location. We moved it after 2 years because we grew a bit, and we moved to Airport Road, but adjacent to Walnut Avenue.
And what were the services provided there, basically?
We had a full lab, which is unusual for a small clinic. We had X-ray, and we provided workers' comp care initially, but then after a period of time, a lot of those employees began to bring their families, mothers, children, and so we opened our practice to workers, to everyone.
Right, and after that point, were you at some point the prison physician? I mean, the county physician here for the county jail?
I was for 11 years.
Okay. Now, was there a time that you left your practice to engage in these humanitarian enterprises that I talked about in my opening statement?
Yes, in 1998.
All right. And can you briefly, I don't want to hear about any specific thing that you, but just generally, what were you doing in these humanitarian efforts?
I carried a small medical team and a few others. We, besides medical, we had one mechanic who was really as valuable as a doctor. We went to the Mosquito Coast of Honduras, and we began triage in different communities, working there with the Mosquito Indians.
And did the organization that you founded have a name?
Corazon, Heart to Heart.
Okay. And what different countries did you do? Were you doing disaster relief or medical relief, or just basically what was the?
Initially it was medical, but the medical need was so great that I wrote a letter to the Cuban embassy, and I begged them, because I'd worked with a couple of Cuban doctors and they were excellent. They weren't like most American doctors, real mamby-pamby and needing everything right. The Cubans could adapt and could function. They were like military physicians. And in fact, a lot of them were military physicians. And the Cuban government sent a medical brigade to Honduras, for which I got in big trouble with the State Department over that letter.
Well, let's don't go there.
Right.
So we're in Honduras. What other countries, if any, did you do the philanthropy and the humanitarian work in?
El Salvador. We've got an operation now in Nicaragua of a different type, but in Nicaragua and Puerto Cabezas, Haiti, and Iran.
Okay. And do you continue to run those enterprises?
I do.
When did you stop practicing medicine?
In the U.S. in 2002, in Honduras, whenever I'm there.
Okay. And why did you stop? Was your license taken from you, or did you surrender it?
I surrendered it.
And what was the reason that you surrendered it?
They wanted me to do a 72-hour mental evaluation, and my captain, I would have done it, but the captain of one of my ships, Don Ware, had been shot, and
Well, we don't need to get in.
I replaced him as captain of the vessel.
Okay. But at any rate, you did not comply with a certain request.
Not initially. I did when I returned into the country 4 months later.
But by that time, had you already surrendered your license?
Yeah, it had.
All right. So you basically are not practicing medicine anymore, but just doing these working within these humanitarian issues. Is that correct?
That's right.
All right. I know there's been talk about you touching your head. Let me just ask it to you anyway. On the videotape and elsewhere, we've heard about the cerebral malaria. I don't want you to give any opinions about it. I just want you to tell us when you contracted it.
2000.
And where were you at the time?
In a village called Waspam on the Cocoa River.
And how did you contract it?
A Sandinista punk hit me with the butt of his AK-47.
Can you now, since I'm asking you to do so, then show us where on your head that blow came?
And you can see there's a huge depression.
All right. And from that you contracted cerebral malaria, which is that chronic with you? Is it, how does it operate?
Well,
I don't want any medical opinions about it. Just tell us basically how often do you have to deal with that issue?
Well, the last time I had hospitalization was in Meridian, Mississippi in 2013. But I haven't needed hospitalization since. I keep it under check with a lot of tricks.
And has that did that blow to the head and the malaria, has that affected you in any way, shape, or form concerning your equilibrium?
Only when I have a flare, or, you know, when I'm thinking that there's, sometimes those little flare-form larvae in there just go nuts and they have a party and they really mess with your head.
All right. Is the stress affected at all, either way?
Seems like it's always a stressful situation, you know, when I've had a flare.
All right. There's been talk on the videotape of you, of your ADHD. Do you in fact have that condition?
Oh, yes.
And when was that condition diagnosed?
1991, Dr. Velimir Savorin,
All right.
a psychiatrist here in town.
And without getting into opinions about what each term means, what do each of the words in that acronym mean?
Attention Deficit Hyperactivity Disorder, ADHD.
All right. Now, you saw the videotape, and we sat there and we watched it together a while ago, as well as at my office. Looking back at that videotape, how do you feel about the way you responded to the officers?
Well, I'm embarrassed. I mean, you know, I gave those guys a hard time. But I think when they slapped the handcuffs on me, you know, like I've been in jail in other countries, and in the U.S. here, I've been in jail before, you know, 52 days once for contempt of court with a judge.
All right, but you have no, as you sit there, you have no criminal conviction. We've been provided your criminal record. You have no convictions of DUIs or any kind of convictions.
No, I have no criminal convictions in any country either.
All right. But you've obviously, what you were speaking of on the video, you've obviously had some run-ins with the authorities over in these other countries.
Yeah, the kind of work we do, you sometimes are asked to be, you know, to pay a bribe to deliver food or medical care. You're asked to pay a bribe, and I've never done that. Well, I have once, but generally no.
Well, what about your alcohol usage? Give us a general impression of what your alcohol usage is on a yearly basis. How many times a year do you think you would engage in any sort of alcohol consumption?
Maybe every couple of months I might have. And it is dependent too, because I drink, when I do drink, I'll drink gin and tonic, and then after the second gin and tonic, I just go straight and ask them to just put tonic in it. No gin, no more, just tonic. Because the tonic has got the quinine hydrochloride that helps arrest the flare-form larvae that are the problem with malaria.
Okay. On the night in question, September 23rd, I believe, tell us what you were doing. Let's get a timeline for the jury from around 7 o'clock that night. And then the stop happens, I believe, around 2 o'clock in the morning. Take us those previous 7 hours. Starting at 7 o'clock, what's your best memory of what you were doing at that time?
7 o'clock, I was coming back in from feeding the cattle, and I took a shower because it was hot, and I got in touch with, or I got a return phone call from Gary Cole, a cousin of mine who just lived down the road.
How long was the phone call?
Gosh, it was like 2 hours.
All right. And then what did you do? And what was the name of the female you were with?
The what?
The female you were with, what's her name?
Elizabeth Beth Leach.
And where is she at now?
I don't know, but I think Ocean Shores, Washington.
Washington State is your best
Right.
understanding of where she's at. You're no longer together, I take it.
No, this event pretty much terminated that relationship.
Okay. Well, that's fine. So anyway, after the 2-hour conversation, what do you do? You're at your residence, all this happens at your residence, correct? Your farm?
That's right. I wanted to order like something delivered or picked up, but she wanted to go out, so we went out.
And where did you go?
We went by Applebee's, okay, and it was so crowded, we drove on toward Chili's, but it was even more crowded. So turned back around and went back into the Applebee's, and I parked in the Veterans parking lot there because they have 2 spots there for.
Now, you heard her say on the videotape that you went to Chili's. So
Yeah.
you disagree with her recollection of where you'd been?
I totally disagree with her recollection of that, but I think probably she was more stressed even than I am because, you know, I've had a lot of experience with law enforcement. She hasn't, and she was probably rattled. We had gone by Chili's, but.
So what
that's
time did you
what we-
actually enter? What time did you actually enter Applebee's? Best estimate.
About 10 minutes till like 11.
Okay. And
Yes, about right.
okay. And tell us, did you eat?
Yep.
All right. Do you remember what you ate?
Yeah, Caesar's is pretty much what I have there when I go. Caesar, chicken Caesar salad.
And how many alcoholic drinks did you
And
have?
Some chicken wings, I think, too. 2
All right. And what type of drinks were these?
gin and tonics. Not doubles either.
Right.
Singles.
So two single.
And then I had 2 more follow-up tonics, just the tonics with like lime added.
Okay. And what time does Applebee's, I mean, how long were y'all at Applebee's? When did you leave?
Well, we left at about 10 after 2, according to a time on a picture that we took at the parking lot where it was out by the car by the veteran sign. I was just pointing at it.
Okay. And did Applebee's actually stop serving alcohol?
Mm-hmm.
What time did they stop serving?
1.
And were people still eating there after 1? Or
Yeah,
did
they let people continue to like sort of mull around, and there was a lot of discussion going on about that Guatemalan pastor who had said the world was coming to an end and gave all these things, and there were some folks in there, and so there was a lot of discussion around the bar, and people were talking about that.
Okay. I meant to ask you this. When you were asked to, when you agreed to surrender your license because you wouldn't go into the inpatient psychological exam, what was the issue regarding any potential psychosis that they were concerned about with you? Was there a particular something you had been involved in that was alerting?
I had an ex-wife that wanted everything I had and used the power of attorney to get it.
Oh, wait a minute, there's an objection.
I'm going to inject this for relevance, Your Honor.
How is that relevant, Your Honor?
Your Honor, I think it shows his a state of mind that he was being perceived by the medical board at the time that had to do with a vision that he had, and that was the basis for him asking for his license to be surrendered. And if I'm fine moving past it, but I meant to ask him about it. And
I believe that would be irrelevant to why we're here today, so.
all right, that's fine.
Disregard any of that testimony.
Yes, ma'am. All right, so let's move back to Applebee's. You're there, you finished your food. What did the lady that you're with, what did she eat as well?
She did.
Okay. And when you left, where did you go?
We, it's a divided highway, so we turned right and proceeded up to the racetrack. I don't know the name of that road that turns in, but anyway, you up around the racetrack and drove into the racetrack parking lot. I think actually we drove through the thing, and I turned right from there onto Walnut, heading in that direction, heading east.
All right, and does your car have automatic headlights?
No,
Okay. And were you aware at the time that your lights weren't on?
not at that time still.
So you proceeded down Walnut and until what point?
Well, I proceeded on Walnut, and the phone rang, and it was my cousin, and we were talking to him, and he said, why don't you come by and we'll smoke a cigar, because he loves to smoke his cigars on his patio. So I turned in at Lakeshore and pulled in there north of the tennis courts in those first spots, backed back out, pulled out, and I think that's probably where the officers picked me up, because according to Officer Smith's report.
Well, let's don't get in there. Let's just get into where you went. You turned into Lakeshore. You turned
turned
around to go where? To your cousin's house?
Yeah, he lives on Oneonta.
Which you had just passed on your left.
I passed Morton.
Oh, and that would lead to Oneonta.
Oneonta.
All right, so you turned around at the next available turnaround.
Right.
And then went the other way up Walnut.
Right.
And then turned in up towards where your cousin
Right.
lives.
When I had the blue lights on, I said, well, I can't stop on this road because it's, steep. Morton's a very steep road. And then I made the right turn onto Oneonta. I knew the officers were behind me. They'd need space to park as well, so I traveled down like maybe past 2 mailboxes and stopped.
All right. So were you having any trouble driving that you remember, that you recollect?
No.
So you're there, you get pulled over, we see the video. You had requested them pretty much from the beginning to go to Hamilton, is that correct?
I wanted blood work, not a blood draw.
All right, and why did you want them to go to Hamilton?
Hamilton does an enzymatic assay test. It gives you results back in like maybe 40 minutes, Even if you're like if they have major trauma, the lab can get to it within a couple hours.
Okay.
Ms. Baxter is objecting, counsel, I've already ruled on this, and this testimony is not admissible.
Well, Your Honor said he could state as to why he chose.
As to why, but not as to comparisons of the different tests and reliability procedures. So you know what's admissible and what's not.
Right, I don't want you to speak, just why you chose this test. I don't want you to say anything negative about the other test. Why did you choose this test at Hamilton, the blood test at Hamilton?
Hamilton doesn't have a gas chromatograph, and they do an enzymatic assay test.
Yeah, well,
All right.
I get the result immediately.
Mr. Foster, please stop talking when there's an objection. Now, what's your objection, Ms. Baxter?
All right, that's specifically what the court ruled on at the bench before. He is not allowed to make those statements.
I remember Your Honor saying what I stated as the immediacy of results and the lack of fermentation in that test. And Your Honor said you were okay. That's all that I'm asking. And if I have to lead you...
That's not what your client is answering. I will instruct this jury to disregard that answer. And Mr. Murray, if you need to take him out again, instruct him on what the court said is admissible and what isn't, and you can do it again.
I'll do my best to lead him, since this is such a dangerous line, Your Honor, with these couple of questions with the court's permission. Is the reason you chose the test because you could get an immediate result back and there would be no chance for fermentation issues?
That's exactly why I ordered it.
All right, no further questions on that point. Did you believe that when you left the scene headed towards Hamilton Medical Center that you were actually going to get your blood tested that night?
Yes.
Right.
I offered to pay for it too.
Well, don't add anything to what I'm asking because we need to be careful here. So when you up until the time your blood was drawn, up until that time, were you ever told by either officer that the testing wasn't going to be done at Hamilton but down at the crime lab?
No.
It was only after the blood had been drawn that you were so informed. Is that correct?
That's right.
And do you have any explanation for, well, let me ask you this. Do you feel like during the that you were ever swaying when they were asking you to stand still?
No, I'd like to see that video again. Let's see where it
Just
makes
do you
sway.
feel, just if you would just
No, I
answer.
wasn't swaying.
Wait a minute, now, you understand with an objection, what is your objection?
Objection, Your Honor, it assumes facts not in evidence. Neither officer testified that Mr. Foster was swaying at any time.
Yes, they wrote it in the report.
Mr. Foster, please, be quiet while we're on the objection. You didn't know this works, now stop. Mr. Murray, do you want to respond to this back to this objection?
Your Honor, I think that I've got the officer on call who indicated in his report, you did not release the officer. He's outside. I can call him next, and I would be asking him to comment on what I expect that officer to say about claiming he was swaying.
But that was not his testimony, that question was not asked by the state.
I was not allowed to ask it at the time because we had not yet seen the video. We have now seen the video in which that incident is depicted on the video. And I intend to get him back up there and ask him, does he still contend that he was swaying? I have a good faith basis, Your Honor, because it's in the incident report. I'm not making it up. It's in there. Ms. Baxter knows it's in there. So I'm going to you allowed me to not release him so I could put him back up once we played the video.
Again, Your Honor, if those statements were in evidence, they would be a perfectly appropriate element of cross-examination, but those statements are not in evidence.
I represent to the court they will be.
The statements are not currently in evidence.
All right, I can reserve the right after I call the officer back in. I'll move on. Do you have any explanation as to why you were having difficulties with the walk and turn or with the leg lift? Do you have any explanation as to what was causing your performance on those?
I had both of my legs broken. I've had one of them was broken in Honduras in 2008. I have almost a frozen ankle on one side. Take that as you as you like.
Do you believe that the 2 drinks that you had made you either less safe or intoxicated that night?
Objection, Your Honor. Your Honor, he is not allowed to, that is an issue for the jury. He's not allowed to testify about whether he believes that drinking alcohol makes him less safe.
I'll stand the objection.
Do you feel like you were intoxicated that night?
No.
Again, Your Honor, objection. He is not, that's the ultimate issue for a jury.
I'll sustain the objection, that is the ultimate issue for primary fact. We cannot say his opinion on that, so we disregard that response.
And you are currently running for Congress, are you not?
I am as a Democrat,
And when is that election?
November the 6th.
All right. That's all I have at this point, Your Honor. I would reserve the right to recall him after I call the officer.
So, anyway, all right, back to the question.
Your Honor, I don't have any questions for this witness.
Officer, remember you're still under oath. I was asking you earlier, we had not played the video, so I was not allowed to ask you about it, but now that I will, do you still contend that you observed my client Swain when the eye test was being conducted?
Objection, Your Honor. That statement is not in evidence. The officer has not testified that Mr. Foster was swaying.
Your Honor, it was shown on the videotape. I have a right to ask him about what was shown on the videotape. His incident report, he accuses him of swaying. I have a good faith basis to ask that question. He is on cross.
Mr. Murray, would you please tell your client what
I'm sorry, I've got- No,
Your Honor, a police report, as the court is well aware, is not evidence. That's why it's not in evidence. The evidence is the officer's testimony, and he has not testified that Mr. Foster was swaying. If he wants to ask him if he was, then he can ask that. But he can't ask him about the contents of his report because they're not in the record.
The report is not in evidence, Mr. Murray.
Your Honor, I will ask him, do you contend that he was swaying?
From my report and what I noted on the scene, yes.
Okay. Having watched did you watch the videotape here, or were you out of the courtroom?
I was out of the room.
But you have watched the videotape.
Yes, sir.
Would you agree that the videotape, it is not apparent at all that he is swaying
No, sir.
during the HGN test?
No, sir.
You don't agree with that, or you do?
I do not.
It doesn't change your opinion, is what you're saying?
No, it does not.
Okay, you contend he was indeed swaying?
Yes, sir.
Okay, that's all.
That's true.
Not on behalf of the state, Judge, I would ask the witness to be excused.
Mr. Ennis, you swear to witness. Swear to witness.
Your Honor, we'll rest.
All right, any rebuttal by the state?
No, Your Honor.
All right.
Your Honor, if the state would ask if I could just have a brief recess before closing.
Why don't we take about a 15-minute recess and counsel, if I could, can I see y'all for just a second?
Sure.
Okay. The jury will take about a 15-minute recess.